All right, I'm not sure if we're live yet. I'm waiting for go. Okay. Hello and welcome to this very special Photo Brigade roundtable. I'm coming to you live. I'm in Columbus, Ohio through Zoom. So first of all, I want to apologize if there's any technical issues. I am here with this roundtable of interesting lawyer type people, but we're here to talk about using Instagram, photo rights you may be giving up when you do so, and possible ways to protect your excuse me, oops, almost did that, protect your photos. So my panelists include James Bartolomei of Duncan Firm and Bryan Hoben. Both are lawyers representing Stephanie Sinclair, which is what this whole panel is about, actually. She had her photo basically used by Mashable, a website. They asked for licensing. She declined them, and they went around that and embedded her Instagram of the photo into their page, which resulted in a lawsuit. Also, we have Mickey Osterreicher of the National Press Photographers Association and Alicia Calzada, excuse me, both of them with NPPA, and Thomas Maddrey of ASMP. So let me go ahead and, let's see here, get you guys up on the screen. How do I do this crap? Okay, there we go. I think everyone's up on the screen right now. I'm assuming so. Everybody give a nice wave. You all are coming to us all over the country. And so, yeah, I'm gonna go ahead and introduce James. You go ahead and take yourself off mute, and maybe we can just sort of go from here. Does that sound good? Oh, first of all, I should also say thank you to Adorama for letting us do this through your Adorama TV, your YouTube page. If you want to ask some questions, there's a chat box here on YouTube. Go ahead and chat, and we'll see if we can't at the end answer some of those questions. This panel will also then be live streamed tomorrow, Thursday at 4 p.m. through Facebook, where you can interact with us all through the chat feature. Again, if you have any further questions that you want to talk about. So with that, I give you James.
Thank you, Robert, and thank you, Adorama, for the opportunity to talk a little bit about this case. As Robert mentioned, I'm a lawyer. I've been practicing about 15 years. I'm with the Duncan Firm in Little Rock, Arkansas. I've got clients in New York and Los Angeles and throughout the rest of the country. And I want Bryan Hoben to take the opportunity now as my co-counsel on this pending case. And I have to sort of alert everyone who's watching and may not be familiar with it. This case is still a pending case, and there's a potential that we're considering right now doing an appeal. So we're going to generally talk about the case and where it stands, and beyond that, it's not something that is final at this point. So we just have to put that caveat that everything today we're talking about is not legal advice, but general discussion about some of the things that we from our analysis of where the case now stands. So Bryan, maybe you can share, starting on slide 3, to get into a little bit of who Stephanie Sinclair is and how the facts of this case came about.
Great. Hi, I'm Bryan Hoben. I'm an attorney in New York. I counsel with Jim regularly on copyright infringement cases and other photographer-related cases. If we want to jump in, Robert, if you want to pull the slides up. Stephanie Sinclair, for those of you who don't know, she's one of the world's most prominent female photographers. She's a National Geographic photographer focusing on women's and girls' rights primarily around the world. She's well known for her body of work encompassing the phenomenon of child marriage. And she got this start in Afghanistan, I believe, where she stumbled upon this phenomenon there where young girls were setting themselves on fire. And while she was on an assignment for something else out of Iraq, she followed that thread, and one thing led to another, and she uncovered this phenomenon of child marriage in the world. And as she was digging, she realized she was meeting with a lot of prominent people in the field, and realized there was no visual evidence of the practice around the world. And for that reason, it hadn't got the traction that it one day would. And so she set about putting faces to these stories from girls around the world. And this led to a handful of stories, and those snowballed into a collection called Too Young to Wed that was launched on the first International Day of the Girl Child at the UN in New York in 2012. And from there, she launched her own nonprofit titled Too Young to Wed as well, based on this topic. And so through that, I think through this work, she was included in this story, this proposal, if we want to bring that slide up. This was a story proposed by somebody from Mashable. You can, yeah, this is the actual image there. I think it was before there was an email.
Oh, sorry. Okay.
Yeah, there we go. Yeah, so you can see somebody from Mashable reached out specifically about this particular story. You know, it was a nice feature on women photographers, some of the top in the world, which, you know, always flattering to be included in this. But as a working photographer, as a lot of y'all who are watching know, you make your living in a large part by licensing images, and you have to be discerning on who you license them to and what for and how much. You know, you take that juggling act into account every time you license an image. This came through, and as you can see, $50 was the offer, and Stephanie declined to finalize this license, was not interested in doing it, so it was never created. This was March 11th. I think the publication turned around March 19th and published this exact story. Anyway, this is the follow-up email. The original email described the context of the story itself. And so they went ahead and ran it anyway, as you can see here on the right of your screen. She was listed among the women photographers, and because she had declined to use the image, they went ahead, and this here on the left side is her Instagram feed, and they just used Instagram's API embedding feature to go ahead and grab that and plop it right down on the screen. No license fee paid, and they rolled on from there. Stephanie wasn't aware of the use immediately, and it came to her attention a little bit farther down the road. Jim, do you want to hop back in? You're
on mute, Jim. Unmute, Jim.
So I'm off of mute. I'm sure my wife is glad that I hit the mute button sometimes. In any event, so that whole set of facts led to filing the lawsuit. I mean, there was some back and forth to understand what Mashable's position was. And ultimately, what it came down to, Robert, the next slide is what exactly did Stephanie Sinclair agree to when she got on Instagram? And it's even a bigger question: is what does everyone agree to on Instagram? And Robert, if you want to go ahead and play that, there's a little bit tongue in cheek. So at the ultimate goal here is that the world, anytime they get on an Instagram, which is owned by Facebook, is what exactly are you giving up, and what do you control, and what do you really own? And I think that question is still very much an unanswered, one from both a consumer and a professional photographer perspective. So Robert, you can go ahead and play that.
All right. Hopefully you guys all can hear this.
The other one is what I call a propaganda problem. Let's start with the privacy problem first. Let's start with the user agreement. Here's what everybody's been trying to tell you today, and I say this gently. Your user agreement sucks. You can spot me 75 IQ points. If I can figure it out, you can figure it out. The purpose of that user agreement is to cover Facebook's rear end. It's not to inform your users about their rights. Now, you know that, and I know that. I'm going to suggest to you that you go back home and rewrite it. And tell your $1,200 an hour lawyers, no disrespect, they're good. But tell them you want it written in English, in non-Swahili, so the average American can understand it. That would be a start. Are you willing, as a Facebook user, are you willing to give me more control over my data?
Senator, as someone who uses Facebook, I believe that you should have complete control over your data.
Okay. Are you?
All right.
So as you can see, that position as of right now still is a lingering one for the professionals of the world. And ultimately, if you go to the next slide, Robert, there is language within the Instagram terms of use that
The other one is what?
basically that tell the user that, hey, if you're coming onto our platform, if you want to use Instagram, you're granting us a license. And in turn, we have the right to sub-license that to anyone we want. And if you go on to the next slide, it brings up the question of, well, wait a second, if Stephanie or any other Instagram user who's sitting in the public mode, private modes is something we'll talk about a little bit later, and everyone who's using Instagram probably knows that there is public and private mode in terms of how you set your account. But ultimately comes down to what exactly did Mashable agree to on their side of their ability to go grab photos off of people's public accounts and embed them. And there's very specific language that at this juncture, and I put the caveat on this, is that we're not exactly sure what is going to, how this thing's going to shake down. But ultimately, if Stephanie owns her user content, she owns the copyright to it, and she's put a restriction or a requirement, or she's denied, in this case, an express license, then that's really where we're ending up on this, and fully trying to get an idea of what exactly the court's going to do. If you go on to the next slide, that's the same email that Bryan showed, where there was a request and for asking permission to use the photo in question, and it was ultimately denied. It is never granted by Stephanie. So from our perspective, are there options now in terms of us to go back and look at the entire universe of solutions? And I think the other folks on this panel today have a good understanding of how to address what do photographers do. So maybe Alicia, you can pick up your thoughts from describe a little bit the organization you're with, and what your members may be able to do in terms of option one.
Yeah, sure. So I'm with the National Press Photographers Association, and our members rely on licensing revenue. And so we found that many of them chose to go private because at the moment that is the only option. One of the things we did was we provided them with a square that explains why they went private, and also some language to put in their bio. Bio is very restricted in terms of the number of characters, but I was able to kind of cut and cut and cut like a good journalist to come up with some language that just basically says why I'm private and that you can click on follow to follow me. And we provided a square for them to put, which obviously people don't see while they're private, but it did give people an outlet for those that do follow them on explaining what they've done. Of course, this isn't an option for everybody, because I think that a lot of photographers really rely on their ability to be out there and market their work to people that they've never met before. And so it's a balancing act, and you really have to, I don't think there's a one size fits all answer for everybody. You have to really make a decision about what the right thing is for you. And that's based on, in part, how much you think this could interfere with your licensing revenue. And it's based in part on how much you rely on marketing from Instagram.
I think that's great. Robert, why don't you take option two, because that is something that, and if I'm going to bring that slide back up, is something that photographers are grappling with, the private versus public mode.
Robert,
Unmute. There we go. Sorry. My wife also likes it when I go on mute sometimes as well. Option number 2 is to switch to private mode on Instagram to prevent embedding your photos. I, as a professional photographer, my use of Instagram has changed over the years. I have, first I used it as a daily catalog of what I used to do throughout the day. It wasn't professional images. There was then a time when I heard that editors were looking at Instagram rather than your actual website. So I started actually putting my real images up. Did I receive any work from it? I'm not exactly sure, but that's what happened. To this day, now I use it as a daily, I have a daily challenge of posting usually an iPhone photo every day, you know, and that's how I use it. It is less desirable, unfortunately, to go from public to private, because then you're limiting who it is that can actually see your image. You're not going to be able to get that reach. And if it's my understanding is correct, and maybe you all can correct me if I'm wrong, if you go private, you lose the ability to see the analytics and to do promoted posts and sort of that whole business side of it. So it's a real bummer when you see, it's a bummer when there's not an ability to remove that feature of embedding like you can in YouTube. I mean, we're all familiar with YouTube, I think, right? Where if you post a video, you can check just no embedding. Very, very simple. Why isn't that available on Instagram? We know that Instagram and Facebook have amazing engineers that can probably bang this out pretty quickly. Maybe not quickly, who knows, but they can do it. Why is the reason? And I have a feeling that reason might have to do with money. I don't know. I could be wrong, but I'm guessing so. Or that information that they want to get from you so that they can sell that information. Just me speaking as a professional photographer, not a lawyer. So do we want to go to that next one? Who's going to take number 3? I'll get back to it.
I'll take that, sure. So, you know, that's really the segue to this in terms of what does Instagram want to do and what are they able to do? We reached out to them. Demanding is not usually a good way to start out. And we started out with a very amicable conversation, talking to them again about the fact that YouTube has that option where you can per post, and it doesn't have to be an either or. You're either private and nobody sees you unless they're approved and invited, versus public where everybody sees you and also comes with the ability for people to embed, which has led to this problem. So we approached that with them. They're very mindful, at least in the conversations we have, that their whole platform is based on visual images, and the visual images come from photographers. I represent the National Press Photographers Association along with Alicia. And, you know, we have so many members that want their work seen out there. But again, it's striking that balance between which is worse, to not be seen and not have somebody have the ability to embed and use your images without permission or a license, or to be seen and risk that happening. So we certainly presented all of that to Instagram, and they promised us that they are working with their engineers to see if indeed it's possible for them to do the same thing and give people individual control over the posting of their image. So it's kind of as a case by case, which some images you may not care whether they're posted in a way that they can be embedded, and some you might want to protect. But hopefully we will hear back from them in short order, and you know, I will be cautiously optimistic that we will get some resolution if indeed they truly want to address the concerns of the people that make up their platform.
Well, that's great. Tom, can you share your perspective on the business side from ASMP and your members?
Sure, absolutely. So I am general counsel for ASMP, the American Society of Media Photographers, and we work hand in hand with Mickey and Alicia and NPPA quite a bit. They represent the photojournalists out there, and our organization represents a lot of commercial photographers who work on things like advertising and everything else. And it became pretty clear a few years ago, as Robert was saying, that your Instagram profile, your Instagram feed for many photographers was supplanting your website in terms of visibility and in terms of connecting you with clients, especially in the commercial photography world. And so, you know, when a case like this comes up, you know, there's two striking things about it that I think are particularly relevant. One is obviously Mashable reached out and offered the small sum of money, which was declined. And, you know, I know that was mentioned at the beginning, but that is such a sticking point for photographers, because there was a clear declination of using her work in this way for this purpose, and they were able to do it anyway. But when it comes to what to do now, what should you do in the moment, I'm incredibly hopeful that the conversations that have been ongoing with Instagram will result in some changes moving forward. But if your choice is to go private, the first thing to understand is that going private means you can't have a business account. Business accounts can't go private. So if you currently are using Instagram to run ads, if you're using it for any type of monetization, if you're using it to track your analytics in the way that it offers, well, to go private, you first have to go to a personal account and then go private. And you lose access to all the data that you've built over years of work. That's you know, as I believe James and Bryan wrote in one of the court filings, that's not a decision that any photographer should have to make, whether to avail themselves of the benefits of social media and the Instagram platform, or have their work used against what they wish to see happen. So from the business side, and from, you know, photographers who are very much in that commercial photography world, I think what's been going on here is distressing on a lot of levels. And if, you know, as Alicia said, you have to make the choice. It's a balance. You know, there are legal decisions and business decisions. And of course, lawyers will always counsel for the most protective measures. But if you're out there right now and you're generating most of your income in photography and most of your visibility from Instagram, boy, that's not something that's easy to do. And so I'm really hopeful that that the talks we're having might result in something. At the same time, we're in a tough place right now with this ruling.
Well, thanks for your thoughts on that. So on option 4, Bryan, do you want to shed some light on some of the areas that you know, we focused on, so everyone can back up procedurally? The case was dismissed on a motion to dismiss. So that's before any fact discovery, meaning we don't get to take depositions. We don't get to ask somebody at Instagram in a deposition, what did you mean when you wrote this? If the plain language of, you know, the various agreements that are at stake aren't clear. So, you know, Bryan, why don't you share some thoughts on, you know, some potential issues that you know, were raised, and, you know, ultimately, you know, we may or may not, you know, bring up on appeal.
Yeah, I think, you know, one of the baseline issues was that it should have been the defendant's responsibility to prove the existence of the license. The way it shook out, the judge assumed it from just the basis of Ms. Sinclair being on the platform. And like Jim, you just said, that deprived us of the ability to go in and do that kind of discovery and have those questions answered directly from the source, which we had anticipated doing. And in digging through that, there's case lines on both coasts in the Ninth Circuit and the Second Circuit that cast a lot of doubt on it's called the browse wrap and click wrap agreements, and a lot of those cast out on whether users actually enter into agreements when they click through terms of service and yeah, and next thing you know, you haven't read anything, but you just by virtue of being on a page, you've entered into agreements supposedly, or clicking through this hybrid agreements. A lot of these are now where you click through and find yourself adhering to terms that you may never have laid eyes on, that may reside elsewhere, tucked away in some strange corner. So whether or not those lines of cases are going to be applicable here, we were deprived of the chance to really find that out. So that was where a lot of the pushback was when we filed a motion for reconsideration on the judge's ruling last week, 2 weeks ago. And that was one of the lead items in there, and that might very well carry over into the appeal. Secondary to that, and maybe, but more in my vein of interest, is really whether the terms of the API, we talked about this in the beginning, whether the terms of the API 11 and A11 and A16, they essentially create a bridge between, the regular user, Instagram user isn't bound by the API terms, only the API users are. But yet this sublicense supposedly flows out from your regular agreement into that API use, and these terms there create a bridge. A11, A16 create this bridge back to the regular user from the API user, and saying the API user has to abide by the restrictions. And outright denial of a license, well, I can't think of a better restriction on a use, can you? It just doesn't make a lot of sense to view it any other way. And the court found that the API license preempted any of that, but again, we didn't get the chance to dig in and do discovery and have the parties come in and explain what things mean. So that's going to be, beyond anything else, I think that, should we go forward with the appeal, or should the judge grant reconsideration on the matter? I think that's where we're going to be focusing on. I think we had a handful of other elements in there if you want to jump in on any of those, but those are my primaries.
Yeah, Robert, if you go to slide, I think it's 12, this was not part of what was attached to her, to her Instagram post. Robert, can you pull slide 12 up?
Yeah, 1 second.
No problem. I know technology. It's
okay. What is this?
So here on slide 12, Bryan spends a lot more time writing licensing agreement language. And again, the caveat: this is not legal advice. It's not proven. It's not a rock solid recommendation that we can all take to the bank as photographers, or even as the average user who's using Instagram, and maybe they think they own their photos. Well, the Mashables of the world, or American Media, or any of the dozens of or hundreds of online publishers are grabbing lots of free content from Instagram. But one of the things that Bryan and I identified in terms of what can photographers do is it going to work? We're not sure. Is putting qualifying restrictions on attached to your photo. So if you post something on your Instagram account, the law doesn't require you to put a copyright symbol. The law doesn't require you to put a watermark or any sort of notice. But if Instagram is telling the Mashables of the world, okay, if you want to go use other people's photos, then if there are restrictions or requirements to that use, i.e. pay me a license, or don't post it, does that win the day? And we don't know the answer to that. And that's where, Thomas had mentioned earlier, and certainly Mickey and Alicia, did as well, is, it would be much better if we had a route to have the platform accommodate the professionals of the world, or, even better yet, going back to some of the appeal issue is the idea that, Stephanie or any other user would go on there and be able to understand what exactly they were agreeing to and what other third parties were agreeing to. Brian and I actually found a study that a university out of England did, and they analyzed the Instagram terms of use. And ultimately what they found is that you would need to understand the 7,000 words and dozens of pages worth of legalese. You would need a PhD in linguistics to actually get through it and understand it. Now, not that I'm aligned with Senator Kennedy, but I agree with him. Their user agreement it sucks. It's really hard to understand what you're giving up and how to protect those rights. And, ultimately, Robert, if we go to the next, slide, that, there's Alicia had come up with something that her organization and Mickey's organization, as well as, Tom's organization are using, slide 13, and maybe they can talk a little bit about that, what effect that may have, in terms of an option for photographers.
Yeah, well, like we said, we offered this square, and there's a link to it on nppa.org. We have a story about just this case itself, and in that story, there's a link to this square if you want to download it and use it. But it gives people the opportunity to let others see their concern and what they've done, and it pushes forward the idea that what we really want from Instagram specifically, separate from what we want from this case and separate from what we want in terms of case law for photographers to have control over their images in accordance with copyright law, separate and apart from that, we want Instagram to provide, and all social media platforms really, to provide mechanisms for those of us providing content to control it.
Yeah, I mean, I think part of the thought behind this is, again, Instagram wants a platform full of images. And when you go to public, if there are enough of these squares showing up instead of seeing beautiful images that are professionally made, that's not going to be a very attractive platform for them when you're scrolling through and you just keep getting a square like this one after the other. But if that's all that photographers have in terms of an option of that either I'm public and everybody gets to see it, but everybody then gets to embed it, versus I'm private and only the people that I recognize will see it, that probably doesn't work for their platform. So we're hoping to not have that either or thing, but a much more viable option. And going back to what Jim said, I mean, we constantly have been telling people for years that they need to read and understand the terms of use, the terms of service that they are agreeing to before starting to use a platform. And the problem is, has been pointed out here by Senator Kennedy and others, that the language has become so dense, so convoluted, so not all in one place that you literally have to click here and then go to a different link and find it and then figure out a way to realize how one thing plays upon the other and what effect that has. I mean, the judge probably had a problem doing that, which is why she just took judicial notice of, yeah, their terms of service, that's it, rather than actually getting into what those terms of service, terms of use actually mean, and what the obligation of Mashable was in terms of what they agreed to when they went on and started using and embedding images. So we're really hopeful, kind of a two-pronged approach. One, that Instagram will agree to change and make it more user-friendly for the people, but also that the judge will reconsider based on these papers and take that deep dive in there and see whether what she said was pretty much clear to everybody is not so clear, and maybe reverse herself.
Tom, what are your thoughts?
Oh, I have so many thoughts, but I definitely echo what Mickey and Alicia said. I think one important thing to note here, and I'll back up a little bit broader even than this case for a second, is, we're talking about copyright law. We're talking about these exclusive rights that are granted to creators, the right to display, the right to reproduce, things like that. And to think about how, your terms of use can grant certain licenses to one group, and then, like in this case, the judge held that there was a sub-license granted from Instagram to Mashable via all these platforms and policies. And again, I absolutely agree with Mickey that everyone should read all their terms of service, and I absolutely don't. I wish I had the patience to do so, and I spend my whole life reading for a living, and so I don't think it's reasonable to take away rights that are granted to creators in a way that is expressly the opposite of what they want their work to be used for, right? I think, even bigger than this case is just that idea. And so, yeah, we certainly hope that these companies will realize that this is a critical factor. I do want to temper everything for a moment and say, let's put this in context of where we are. I think the Sinclair holding was made a lot of people in the industry and across the world very concerned, as well it should. I know our members and NPPA's members, all photographers, were very concerned about it. At the same time, it is certainly one decision by one judge at what amounts to the lower levels of the federal system, and there are going to be opportunities to remedy some of this thing. And I know it started with the motion for reconsideration that Jim and Bryan filed on behalf of Ms. Sinclair. And you never know. Once things get to court, you never know what's going to happen. But one of the most concerning things to me about this whole situation is that Stephanie and her attorneys didn't have a chance to put on their case. They didn't have a chance to do discovery, to figure out this information. It was kicked out at such an early stage, and that's concerning not only for this case, but for many other cases that might be similar to it. And so we're definitely in support of that motion for reconsideration, and I hope the judge will take notice of some of these things that we're talking about, because that decision had wide-ranging ripples in the pond throughout the visual creator community.
Tom, can I ask you a follow-up on that? Because I think it's important to articulate those concerns. Ultimately, if we were able to get through fact discovery and the result ends up the same way, meaning Stephanie uses Instagram, she gives Instagram the right in the form of a license, and then Instagram can go do what they're going to do with it to give it to the Mashables of the world. In some respects, the reason Bryan and I took this case on was, it sort of represented a Band-Aid that's being ripped off. And, all it's done is allow one court, like you mentioned, Southern District of New York, that's not binding on anywhere else in the country, except maybe in a persuasive way for other courts to look at. The result could have been the same. All it's doing is articulating, from what I see, an inequitable injustice for photographers, if that's really the way Instagram meant for the system to be set up.
Right. I think one thing that's, that stuck out to me was, this case didn't involve Instagram directly. This is Ziff Davis and Mashable. And I think that what you're seeing is there's a door that was opened by Instagram that Mashable just went through. And I can't imagine that was Instagram's intent. is to have someone who asked the photographer for a license, was denied, and then was able to just use it anyway. That is likely not the intent, but it's the practical application. And so when you talk about if we went through fact discovery and the end result was the same, I do think there's important, the more information gets out there, the more that you can look at and discover things in court about all the different players, the more you can determine if maybe this is something that goes on all the time. And this just happened to be, Ms. Sinclair stood up and said, hey, this happened to me and this isn't right. And I feel like this happens a lot more than photographers know. When I have clients or members who talk to me about it and I say, have you been infringed? And they say no, the question really should be, do you know that you've been infringed? Because I think most professional photographers have been infringed in some form or fashion. They may not even know about it. And so, I think the efforts of the trade associations and the efforts of you guys in the case, hopefully the combination there can help get some equity in the future.
Go ahead, Mickey.
So many of these cases are so fact specific. You change one fact, it changes the whole case. I really do hope that they do grant the motion for reconsideration, because the one point that you also brought up in your papers, which I think is really important, is we saw another case, Goldman v. Breitbart. And in that case, it was an embedding case also. But where that hinged is that Mr. Goldman put up an image that somebody else then took and posted on that platform. Mr. Goldman never agreed to the terms of use because he wasn't the one doing the posting. And I think the point that you make is at the time that Stephanie joined Instagram, you're not quite sure of whether she was just able to download that app onto her phone and not have to agree to anything. She could just start using it as soon as the app was installed. And therefore, is there an agreement? Did she grant Instagram a license to then grant a sublicense? And I think all of those questions are so important and need to be explored. And hopefully the court will grant you that opportunity.
I would like to add that I think what people who are watching might see is that you have a room full of lawyers who struggle to interpret these terms and all of the relevant case law, and that things may come out differently based on a wide variety of things. And so I'm sure that it can be very intimidating. And what I would encourage photographers to do is what any of us can do, which is the best we can. And so I just ask that you don't put your head in the sand. Try to understand the terms, read what you can about these things. You may or may not come out with the right answer on what this stuff means, because as you can see, some of this stuff is still open for debate. And with many legal issues, the answer is maybe, or it depends. And so what I would just urge is that you stay aware, keep reading about this stuff, keep making decisions, be open to changing your behavior based on new things that you learn, but don't keep your head in the sand. Because I think that the intimidation factor can result in people just saying, it's too much, I can't deal with it. But I would encourage you to just kind of pay attention and think about these things.
And not only that, but one of the things that our members at both NPPA and ASMP get the benefit of is when you're reading things, not just with these terms of service, terms of use, but contracts that people get for assignments and things like that. And our members reach out to us and we try as best we can to answer those questions for them. So if you're a member of any organization, feel free to contact the organization, and you may not get specific questions answered because we don't represent individual members, but generally we can help point you in the right direction and oftentimes give you a little bit more than it depends.
Do any of you have any thoughts on the fact, if the facts were changed in Stephanie's case, which Tom had alluded to, that it happens all the time, the infringing activity of professional photographers who are getting their their photos displayed and used, without permission from others. If Mashable had not come to Stephanie, and that's the bigger overarching question, because like Mickey said, every case is different in terms of facts. And in this instance, we do have facts of an express request for a license, but if that didn't exist, would we still be dealing with this sort of, gray zone where photographers don't really know their rights? Or is it pretty cut and dry in terms of what the terms of service or terms of use say here?
Well, I think one of the problems is, and things that keep, Tom and Alicia and I up at night, is this case going to embolden other publications to just go ahead and not ask and just take and embed and think that they can get away with it? Very similar to the way that they have safe harbor in terms of the less they do in moderating a site, the more protection that they get. It's kind of that willful blindness in a way of like, I don't want to know whether I can have a license or I can't have a license. I think I do have a sub license from Instagram, and I'm not going to ask anybody, because if I do and I get told no because $50 is too little, then now all of a sudden we've got some evidence that says I was denied that license and I went ahead and used it against the copyright holder's wishes anyway. So that's one of the things that we worry about, is that if this stands, it's going to make things worse, as publications think that they have a free-for-all to any images that are posted up there in a public setting.
And one of the things that I've done is, I advise publications and companies on photo usage, and I would never greenlight a policy of doing what Mickey just described. And so I would hope that if anyone who's watching this doesn't see it as something to embolden them on that kind of behavior, because if you look at, for example, the Goldman case or AFP versus Morale, you just don't know whether the work that you're taking off social media was actually put up there. And so you can't even really rely on the terms of service unless you know the province. And so, I want to say to anybody who's watching and thinks this is sort of a free-for-all, that, you shouldn't consider it that way.
I have something to interject here. First of all, if anybody has any direct questions, feel free to do so in the comments on YouTube, or if you're watching this the following day on Facebook, in the comments below. But a lot of people in the comments section are talking about, and this kind of segues into if the facts were changed, what about watermarks? Does that the fact if somebody adds a watermark on their picture change the facts of a case? I know that James has represented me in the past in different instances in which I have had watermarked photos ripped off. And it seemed to help, although it didn't go to court, right? So there's that. And then also some people are talking about, and this goes to what Alicia was saying, what about the fact that the photos could be taken down after the fact? So I would imagine that if any publication goes ahead and publishes an embedded photo, and that photographer then yanks that photo, that's a dead spot right there afterwards. So there's a trade-off when somebody doesn't get their license, uses an embed, and then all of a sudden has a dead space if that photographer yanks the photo. So a lot of people are asking about the watermark. What about watermarks?
So at least the way I understand it is, with the embedding, the way the image looks on Instagram, with a watermark, without a watermark, that's the way it's going to show up when somebody embeds the image. It's not like in your case, Robert, if somebody took the image somehow and then was able to take the watermark out. Maybe it's technologically feasible to do that, but I don't think that's the way embedding works. It's like the image doesn't reside actually on Mashable's site. It resides on Instagram. And the minute Stephanie changed that setting from public to private, that spot that they had just goes blank. So I don't think there's a way to change the watermark. And that said, is if somebody wants to take it and embed it, they're going to have to take it that way with the watermark, and they're going to have to make the decision as to whether the watermark makes the picture usable or aesthetically pleasing enough or whatever. So depending on where you put it, like if you still can see a beautiful image and still can get people to recognize you, but you've got a watermark that goes diagonally across the entire picture, that's not going to make it too appealing to somebody to use in that way. But that's just my opinion. I'd love to hear what Tom and Alicia have to say.
So it deters people perhaps from using it because they see that copyright and they think, oh, wait a second, look, maybe we should rethink this because somebody's taken the time to put their watermark copyright notice. The way I do it is copyright Robert Caplin, robertcaplin.com. So I don't do it across, obviously that would deter a news publication if you basically destroy the photo. And that's what a lot of people are saying on the chat right now is, just slap a huge watermark over it. And I think everybody can agree, as much as we care about our copyrights, that's just, destroying an image, when you throw an ugly watermark right over the subject of the image. That's why, the Gettys and Reuters and whomever slap them all over the place so that nobody uses them. I guess another question is I know that we've uploaded these photos to Instagram, even with a watermark. Does that in any way help the photographer's case? Should they be infringed in this way? What happened with mine is they took that, screenshotted it, and uploaded it on their Instagram account, which is a totally different usage than what happened in this case that we're discussing right now. Facts are different, but if they embedded it with the copyright and it just appeared exactly how I uploaded it with my name and all that kind of stuff, does that change anything?
Yeah, so I think if we can get an answer on whether the API terms that Instagram put in there serve to block what Mashable is claiming they have, that could be useful. I'd be interested to see what you guys think about that. Those of you that are making those arguments.
You're both muted.
Oh, good. No.
Oh, no. I was saying James and Brian are talking. They're both muted.
Oh, sorry. Am I unmuted? I was going to say, one of the things that we discovered throughout the process of what we could find on Instagram changing their terms since about 2011 or 12 is they went from a time period in which if a Mashable had violated the Instagram platform policy, their rights under it were automatically terminated. In other words, they lost the right to the sublicense. They did away with that sometime in 2015. And what we discovered is that Instagram, what we don't know is what that forum is to decide whether a violation has occurred and what's the remedy. So if they have a line in there that says, okay, Mashable, if you violate that user restriction that they put on their photo, what happens in that instance? And does Instagram hold court? They can't possibly be able to do that. So from what we read is that it goes back into the court system, and that's where the fact discovery really needs to unfold, is what happens in the instance of a violation.
Mm-hmm. Yeah, there's no, unlike some of the other content reporting features that Instagram has, there's no mechanism for reporting API abuse in that same way. There's really leaves you with nothing written in stone in those policies to follow through on anything like that.
Robert, in answer to your question again, just my thoughts are that I think putting your watermark, putting your copyright notice on it really doesn't change the calculus unless somebody tries to change that. Because nobody's saying that Stephanie, if it was watermarked or copyright noticed, is not the owner of that image. Nobody's saying that she gave up her copyright or she did anything. So the fact that somebody is willing to use it with that watermark up there, you know, then that's the way they're willing to use it. I think just, you know, if there's a way that people can still see your image, appreciate your composition, the work for itself, and still then have it in such a way that, yeah, but we don't really want to use it. As you said, it's why Getty has them watermarked in such a way of, you want to license this? Not a problem. We'll give you the picture without the watermark and with a license.
For 20,
try
10
and knock
bucks
yourself
or
out
something.
by using it that way.
Oh, Getty.
Yeah. I just want to interject. You see that a lot outside of the Instagram platform, where there's usage, the watermarks and notices come into play for damages determination of willfulness, and then you have your 1202 copyright removal information add on as well, and that's where you see the watermarks really come into play.
Right. So that's a different case than what we're talking about.
Sure, yeah.
Obviously, it seems through this discussion that the answer really is for Instagram to do the right thing and allow photographers to take embedding off, and that would solve the problem, right? I mean, obviously there'll still be people, you know, taking images, but they'll be doing it in such a way that they're removing it and putting it onto theirs. Am I right, or what are your thoughts?
I think it would solve this specific problem, which isn't to say it solves other problems. It would. I think it needs to be an initial step, right? You know, it's giving the photographer control over how their images are used. Probably should be pretty high up there on a list of priorities on a site like this. And would it prevent a case like this from occurring? Well, let's see how it's implemented, right? What if it's, what if you didn't opt out of it because you didn't know that feature was there, and then it was used and it was against your wishes, kind of thing? You know, it is very fact specific, but I think that is an incredibly good and an incredibly important first step.
Question. I don't know that I have had an embed happen. If you are embedded, do you get some sort of alert, some sort of notification of embed?
I don't believe so. I don't believe so. That's a great question. I'm almost certain not, but I bet if I'm wrong, someone will let me know.
I've not.
How did Stephanie become aware of it? Was it just by somebody sending her a link or her searching her name or something like that?
Yeah, I think regularly combing for infringements, irregularly probably. But I think she didn't catch it for another year and a half or so after the use. She after the license was declined, she just forgot all about it, and then one day just happened upon the article. So to my knowledge, no notification goes out for somebody embeds your work.
Yeah, and it's interesting too, because I believe there was 10 female photographers that were featured in the article in question, 10 top photographers in the world, and 7 out of the 10 they used the Instagram embed feature, and 3 they actually presumably went, or I don't want to assume, but they used the actual photo, and maybe the photographer took the $50 and said yes.
Can I have a question? Can we address a question from the people that are watching?
Let's do it. Yeah.
So Pete Keyhart asks, he's curious whether the panel believes that the terms of service as written allow Instagram to go further than just embedding an image. Could Instagram sell an unembedded image if they wanted to, for example?
Ooh, that brings up that whole hullabaloo from 2012 with where they attempted or floated the idea of changing the terms of service to permit that. They said, we can license out your images for money, and that was led to National Geographic doing that whole black square on their Instagram post to protest this, and many other photographers as well. And what is Nat Geo at that point was well under 1 million, and they're God knows what they are now. But that was enough pressure to get Instagram to back off, and we haven't heard any talk of that since.
Yeah, it just shows the strength in numbers. I mean, I think had National Geo not done that, even though their numbers were a lot lower, then they were still significant. That might be part of the terms of service now. I mean, that's the whole thing, is that, you know, people really need to think about all of these things and how they proceed, just the same way as when they get these onerous contracts from news organizations. If everybody signs them and is willing to work for nothing and give all their rights away, then they're just going to keep doing it. If pretty much everybody says, no, we don't like those terms, we're not going to agree to them, they'll change the terms, or they're going to just suffer and get, you know, less quality by hiring people that are not of the same caliber, but are willing to accept those terms. So that, again, that's why it's so important to recognize, you know, what those terms say and understand what it means by agreeing to them.
Daryl asks, good segue, can an organization say that if you don't understand the terms of service agreement, then you made the choice to know that you're taking a risk, therefore you cannot hold the organization liable? Is there a certain, you know, thoughts?
Well, I mean, in contract law, you know, if you didn't read your 300-page contract where you bought your house, that doesn't mean that you're not held accountable to the terms in that contract. And so, so yeah, I mean, you can't, assuming that a contract was validly entered into, saying that I didn't take the time to understand what's in it is a fairly poor defense most of the time.
But on the other hand, you know, we've seen, let's say in used car sales, the agreements used to have these tiny, you know, like 6-point a page in the back that was almost unreadable. And, you know, the Consumer Protection Bureau, others weighed in and said, wait a minute, you can't have terms like this where people are signing things and they can't barely even see them and read them. So it's the same thing, you know, here. I think if there was that overreach, I think if enough people complain, something would change. But I totally agree with Alicia. At this point, we haven't gotten there, even though Senator Kennedy says, go back and rewrite it in English so anybody can understand it. But right now they're there. And if you've agreed to them, then you've agreed to them.
Are the terms of service for Instagram and Facebook basically the same? So are we talking about the same thing? I know they're all under the same umbrella of Facebook these days. Are the pictures we upload to Facebook pretty much going under the same terms of service? I haven't seen an embed option, at least I'm not aware of it yet.
No,
Well, I mean, Facebook does have different functionality. You know, you can have your post be private or public, and so a lot of the rights that you give Facebook are dependent on that. Tom.
Yeah, I was going to say they're not equivalent, and they're not equivalent related to you know, photography, even though they're owned by the same company. Now, when we wrote our initial letter to Instagram, we wrote along with NPPA and all the people that you saw on that graphic that was there. We sent it to Adam Mosseri, the CEO of Instagram, and we sent it to Mark Zuckerberg. And I don't know that either of them read it, but the conversation's been started on that. And the terms of service there are different because the functionality is so very different. And I don't know, Jim and Brian, have you guys run into to that argument so far?
No, we didn't do that analysis. I mean, I'm generally aware that there actually are some privacy legislation that's maybe winding its way through the United States Senate. So ultimately, is it going to apply to technology companies in general? And I know California has been very active in that regard, because, in this instance, Instagram is using, privacy to be synonymous with, rights that you're giving away based on, that private versus public, mode. And granted, we're all, half of us or more than half of us on this call are lawyers today, but, privacy has, very specific, legal meaning. So, how the privacy policies apply, to Facebook and what they can do with your data. The short answer is no, but, will legislation, within the U.S. Congress come through? That's it's very slow to get anything, done. So it's better that Facebook, who controls and owns Instagram, come up with that solution, which is what y'all are working on.
So should we segue into these slides about what are NPPA and ASMP doing? Thoughts on that? Or did we already discuss? Oh, you're on mute. You're on mute.
I was going to say, I think we've covered those slides, but to the extent that there are other talking or other areas that y'all want to elaborate on, I think that'd be great.
Well, I'll elaborate for a second and maybe broaden it out to say this is a great example of the benefits of being involved in trade associations. ASMP and NPPA and others, as soon as this came out, we were all over this trying to make some effective changes, and hopefully we're on the right road for that. There is power in numbers, like was referenced with the Nat Geo issue. And so if you're not involved in some of these trade organizations, it really is worth checking into it. And as a quick aside, one of the issues that's lurking in the background here is even if this was copyright infringement and the court said it was copyright infringement lawsuits are still incredibly long and incredibly expensive, and is a deterrent for people pursuing their rights. And ASMP and many other organizations have been focused for quite a while on the CASE Act, which is winding its way through Congress, which is the Small Claims Copyright Court. Giving creators a way to pursue these things, I think, is really important. And so the work that's being done by these various organizations, I think, can really make some effective change, and it's important to note.
Yeah, absolutely. I mean, we can only have these conversations on behalf of creators if we have members. So the more we have, the more authority we have, and the more authority we speak with, and we're here to listen to you and think about what you need and what your solutions are and how these things affect you. Because part of it too is, we can sit and talk about what we think, but you guys are on the ground. You guys are the ones that can tell us, this is how I'm impacted and this is what this does to my business. And so, we're here to listen to you and support you.
Yeah, as the voice of visual journalists, our voice can only be stronger depending on how many members we have. I mean, just look, for example, at the NRA. When they say something, whether you believe in them or not, Congress and others pay attention because they have so many members and their voice is very powerful. And we spend a lot of time, as Tom said, not only did we jump on this and try to figure out a way, the best way to resolve it, and reaching out to Bryan and to Jim and seeing how we could be helpful, but we've also tried to explain it to people that are writing stories about this. I mean, a couple of us had cringed at some of the headlines that were written, where, you're giving up your copyright. You're doing, I mean, it's like things that was not what the holding of this decision was. But, there were people who didn't understand it, who got assigned to write a story. And sometimes headline writers don't even read the story and just think, well, that's a much catchier headline. And it leads people to the wrong conclusions. So being able to do all of those things is so important in terms of the kinds of things that we try and do.
So Robert, it sounds like it's a three-prong attack. You've got the advocacy from the various industry groups. You've got the litigation front, which isn't always solve the problem. And then you have legislation, and they're all working in tandem, to hopefully achieve the same goals.
Yeah, sounds like it. I'm trying to search at the same time for questions. I've got so much going on my screen right now. It's making me go crazy. People are saying join ASMP, join NPPA. That's awesome. All right. Well, is there anything else that we wanted to discuss? I know we were already an hour and 10 minutes into this discussion, which is a pretty long time to listen to a bunch of lawyers yammer on. Let's see here. Let's take this off grid mode here. That's on my big face. Is there anything else that we need to address that we haven't addressed in this talk?
I do see a comment here that says, what protections are there for photographers who are not full-time professionals? And you guys have the same copyrights that we do. Professional photographers who are listening probably already know this, but anyone who creates a work, whether it's a visual work or a written work, the moment that work is created, you own the copyright. There are things you can do to enhance those rights, but the ownership of the copyright to your work is not limited to professionals.
It's a good point to jump in and just plead with people to register the copyrights. You can't avail yourself of the remedies in federal court under the Copyright Act if you don't register. So please, everybody, work it into your business model to register your work early and often.
Yeah, it's like, fill out your census paperwork, wash your hands, and register your copyrights.
Right.
The census. They keep sending me notes. All right. Well, what do you guys think? You think we should end it there?
Well, we could probably go on all night, so
we better end it there. Then
might be a good ending point.
Yeah. So first of all, I just want to thank all of the panelists for being on and representing your clients, your organizations. Taking the time to discuss this important case. I know there's been a lot of discussion about it going on over the interwebs, and I'm glad that we were able to, all come together in one place and do this. I mean, this is the first time I'm using Zoom to go live through YouTube, and then tomorrow through Facebook, it'll be pushed there. So I'm really pumped that this worked out. I also want to say thank you to Adorama for giving us the platform to put this through their YouTube page, their Adorama TV. If you aren't already subscribed to it, this conversation will continue over on Facebook tomorrow. We're going to, assuming everything downloads properly from the cloud, we're going to go ahead and try to live stream it and premiere it on Adorama's Facebook page, as well as maybe if we can co-host or whatever the technical word is on all our other platforms as well. At which point, I think most of us are available to be there in real time and answer any questions that maybe we didn't address today. So other than that, please, if you are a professional photographer or a news photographer, consider joining the organizations that are represented here, ASMP and NPPA. Look them up, follow follow them on the social media, right? Yeah, thank you guys. Appreciate you.
Well, thank you, Robert. We really appreciate you and Adorama for having us. Bryan and Jim, it's really been a pleasure meeting you and starting to work with you. And I, from your pen to the judge's ears, I hope she will reconsider. Tom, it's always wonderful working with you. And I'm saving Alicia for last because she's the person I think we both kind of try and keep each other's sanity by being able to commiserate with each other on all of the issues that are so important and affect all of us. So thank you all.
Awesome, everybody. Okay, I'm going to try to end this sucker. I'm going to push some buttons. I'm going to hit stop. So goodbye, world. And we all
Everybody.
still might be here.
Thank you so much.
Yeah, thank you again.
Okay. All right, here we go. Stop live stream.